everybody. I'm very glad to welcome you. I'm Céline Castor-Renard. I'm a law professor at the Civil Law Faculty at the University of Ottawa, and I hold a chair on accountable AI in a global context. Today, we have the pleasure with Obvia and also with Danielle Bélanger, who is the woman who is in charge and who is the leader of this project. We have the pleasure to welcome you for a session, for a webinar on the impact of automation and artificial intelligence on immigration to Canada. And this webinar is organized with Obvia. And the webinar will be available later on the website of Obvia and probably on YouTube. We have a webinar, a one hour webinar today with five very prestigious and interesting panelists, and I'm very honored and glad to welcome them. And we will have a Q&A session for 25 minutes, and you could ask your question on the Q&A button on your screen. And just to briefly setting the scene about the impact of automation and AI on immigration to Canada, I just want to give you very few words about the context, the general context of this question. I just want to say that in many countries, governments are using technology to facilitate the administration of legal matters and the provision of services to the public in various contexts, such as education, social security, law enforcement, and immigration. And just to give you a first definition, and maybe our guest will have other definition, we will see, but just to give you a definition of automated decision system, we can say that this is any technology that assists or replaces the judgment of human decision makers using several techniques such as rules-based system, regression analysis, predictive analytics, machine learning, deep learning, neural network, or other techniques. And when such automated systems are used by administrative agencies, they offer several advantages, or they're supposed to offer several advantages. The first series of benefits could be efficiency, speed, and scalability. A second series of benefits is supposed to be cost reduction. And also a third series of advantages could be consistency, accuracy, and better access to services. And of course, we will challenge these advantages, and we will see if it is really the case on the ground. And however, we also see some risk with the use of this kind of systems. And I guess we are here to talk about this risk and these problems. And while these systems are expected to improve efficiency of the public governments, they also raise concerns widely denounced over accountability, transparency, fairness, risk of discrimination, errors, and lack of empathy. Because of this risk, the existence of this kind of risk has led some legislators to regulate the use of automated decision-making, particularly in its application within government functions. And in Canada, the Canadian federal government took an original approach by enacting a directive on automated decision-making in 2019. And the justification of the adoption of such directive is the government of Canada is increasingly looking to use AI to make or support administrative decisions to improve service delivery. The government is committed to using AI compatibly with fundamental principles of administrative law, such as transparency, accountability, legality, and procedural fairness. Understanding that this technology is changing rapidly, this directive will continue to evolve to ensure that it remains relevant. And of course, we'll challenge this affirmation from the government. The purpose of the directive is to ensure that departments are transparent, accountable, and fair in their automated decision-making process. And the Treasury Board of Canada Secretary oversees its application and publishes substantial documentation to assist stakeholders in complying with this directive. The directive applies to departments that are using automated decision systems to fully or partially automate an administrative decision. And this directive applies to two systems developed or procured after April 2020. And moreover, not all AI used for federal public services falls under this directive. Only AI systems involved in administrative decision-making when providing services to clients are required to comply. And the directive is completed by an algorithmic impact assessment tool. Of course, we should also remind the necessity to comply with other regulations or other legislations, such as the Federal Data Protection Law on Public Sector, the Privacy Act, which first came into force in 1983. Despite the adoption of the directive, and I think we are here for discussing these issues, a number of issues have been raised in the application of automated systems to immigration, and specifically to immigration in Canada. And Quebec also faces challenges in this domain. So to discuss these issues today, we have the pleasure to have with us a lot of very important people on these issues, and lawyers and practitioners, and I'm very proud to meet them and to discuss with them, because they work on the ground and they know what are the problems for people, and I'm looking forward to hearing them. And first of all, I would like to let the floor to Danielle Bélanger. As I said earlier, she's the one who is in charge of this very interesting project, and I'm sure she will explain more. Danielle Bélanger holds the Canadian Research Chair in Global Migration Processes and is a full professor in the Department of Geography at Université Laval. She's a principal investigator of the Immigration Artificial Intelligence Automation Project, which is behind this webinar. And Danielle, this is my pleasure to let you the floor. Thank you.
Thank you so much, Céline, and I wanted to thank Céline for having accepted to chair this seminar today, this webinar. And I want to just briefly say a few words about this larger SSHRC-funded project. So here we have the composition of our team, and we're very excited to collaborate with immigration lawyers who are really at the forefront of the repercussions of introducing automated decision support systems in Canadian immigration. They are frequently solicited to share their experiences. They train professionals in the legal profession, and we wish to bring their unique experiences and insight to the academic community today. So thank you as well to Obvia for sponsoring our workshop and being there with us. So what I'll bring to you today is really a social science perspective on discretion in the era of automated decision support systems in Canadian immigration. Now, there are many definitions in social science what is discretion. So I will use this one used by some of my colleagues who are been working on this for many years, Gelstorp and Padfield, who say that discretion refers to the freedom, power, authority, decision, or leeway of an official, organization, or individual to decide, discern, or determine, to make a judgment, choice, or decision about alternative courses. And that's really important, alternative courses. So immigration practitioners, some of whom who will present today, began to suspect changes in the way decisions were made by visa officers around 2019, 2020. The use of one tool called Chinook was eventually revealed at the federal court in 2021 in the Okren case, a challenge of a study permit refusal. Today, at least 10 new and different tools are currently used by RCC to perform various tasks aimed at processing immigration applications, some of which use AI, others featuring less sophisticated automation. Vic Sasewicz, a sociologist working at McMaster, studied discretion among visa officers in 11 visa offices prior to 2012. And this is our focus, human discretion among visa officers in making decisions about files. So in his study, he underscored constraints, including regionally established quotas, pressures to process files quickly, and the priority put on fraud detection. His study is really interesting because it establishes a baseline of how we understand discretion prior to automation. So this question matters for us because RCC states that the decision-making process is not altered by the new software tools. So what we wish to do is to confront these assertions with the scientific literature on the introduction of automation and AI in public administrations. As Céline pointed out, it's a much bigger process underway. So in the following analysis, which I'll present very briefly, we'll focus on this tool I just mentioned, Chinook, because this is the one for which our colleagues who are panelists here today obtain the largest and most detailed information about. So in a few words, it was implemented in 2018. It's described by RCC as a tool for temporary resident application processing to increase efficiency and reduce processing times. It displays information stored in the global case management system. It's not an AI, but it interacts with many other systems that use AI in bringing information into the Chinook system. So I will bring forward 4 points today to argue that process is different and process is at stake in decisions. I will not speak to decisions. I will leave it to my colleagues. But from a social science perspective, what do we learn about this? So first of all, we know from existing literature in this area that as generally speaking, systems multiply actors who exercise discretion. So in the case of immigration, we know that decisions are made based on information provided by different actors and tools with their own discretion along the way. While some of this existed before 2015, the introduction of automated systems takes this complexity to a new level and spreads discretion among various actors, obviously some of whom are software and algorithm developers. Also, in the case we're interested in some of the tasks supposed to be performed by the officers, some of these tasks are now assigned to locally hired staff that pre-process information and encode it into information blocks ready to be used by the officers. Done for the sake of saving time and implementing stable assessment standards, this nonetheless displaces the site of discretion in these particular assessments to the local staff who are not officers and do not work for IHCC. And I should say before I move on that a lot of the information I bring forward today comes from a very numerous ATIP requests done and shared by Gabriel Bergevin-Stable, my co-author, and his colleagues who are here today in the panel. So this bulk of information has provided a lot of what I'm talking about. So moving in more specifically, Systems alter the temporality of the decision-making process, and this is important in the social science literature. How fast can we go? Of course, the objective of this introduction, as Cécile has pointed out, is to improve client service delivery, to speed up the file processing, reduce waiting times. However, we know that with this speeding, it also, in the speeding of processing, it reduces human engagement with specific cases. So one objective of introducing Chinook and other tools at IRCC is to speed up, but also harmonize the processing of files to reduce those waiting times. In Vic Sasewicz study, officers from information we sort of gathered throughout the book, we can infer that officers were taking between 3 and 11 minutes per file and still felt pressure to process faster. IRCC does not share on what basis Chinook allows faster processing, but instructs officers in making group processing of applications with the tool. So similarly, with precursor tool Iraya, these gains in processing speed were largely attributed to the group processing with automation of masses of decisions, which could only be done using the global case management system and form fillable data without attachment contents, and that's really important. So IRCC own time and motion study obtained by our colleagues indicates that applications were processed on average under 102 seconds using Chinook. So those gains in processing speed are so great that it's hard to explain how officers could process such applications so fast while still considering all attachments, and how they could still be engaging with the particulars of the case. Now, thirdly, systems alter the spatiality of decision-making process. So this is spatiality in terms of space in social science. In Vic Sasewicz research, the place where decision was made really mattered. Local knowledge of culture, society, institutions, practices, and policies were center stage to decision-making. For instance, he talks in his book about what are the cultural markers of a real relationship, of an authentic local wedding, for instance. One of the objectives of the introduction of Chinook is the harmonization of practices and procedures to increase quality decision across different visa offices and the facilitation of workload sharing between different offices. Document analysis revealed that the instructions to visa officers at a secondary office processing a request tells them to erase their assignment to the file after performing their tasks. It is also known in the legal field among our colleagues here that more and more refusal letters omit to indicate the office that made the decision. So this raises the question as what's happening to local expertise? There's one module in Chinook that's supposed to deal with these local word flags, but it's hard to figure out at this point how it really works. Fourthly, my last point is that systems alter the analysis process of files. And here, I don't have time to go into detail, and the collaborators here with Gabrielle and I have greatly reflected upon this, but really, we know that Chinook work is a tool that triages file according to risk levels in tiers that require more or less attention from visa officers. So tier 1 files receive automatic eligibility approval, while tier 3 require the greatest attention from officers. Officers may not know by which rule or why the advanced analytics AI system may have triaged an application to be reviewed by them for eligibility, but they know that such files are of higher risk or higher complexity than those auto-approved by the system. Interestingly, data we obtained indicates that the proportions of tier 3 files that are rejected vary significantly between offices. So IRCC says it has methods to prevent and monitor the risk of automation bias, but it has not been forthcoming as it's to its design nor effectiveness. So in conclusion, how does process impact decisions? And my colleagues will elaborate on this in their presentations. On IRCC website, you can read this. You know, in the case of a recent decision, Justice Brown stated that an officer's use of Chinook or an AI tool is irrelevant. Rather, the focus should be on whether an officer's decision is reasonable, and to hold otherwise would be to elevate process over substance. So this is a very problematic statement for us. Social insight into the exercise of discretion in the context of automation and AI in public administrations indicates that process is at the heart of the way decisions are made and cannot be dissociated from decisions. The process followed is part of what makes a decision reasonable, we believe. So as we will see from our collaborators who are dealing with decisions that involve some of the systems in place, it's critical for access to justice, procedural fairness, equity, and transparency. So thank you very much.
Thank you, Danielle. And I agree with your last sentence. And I'm sure everybody would be in this webinar among our panelists. Our second panelist is Lou Janssen-Dangsalan, and it's a great pleasure to welcome you, Lou. Lou Janssen-Dangsalan is the founder and principal litigator at LGD Law in Toronto. He has acted as an expert witness for committees in both chambers of parliament and is a sitting board member of CILA, Canadian Immigration Lawyers Association. This is my pleasure to welcome you, Lou, and the floor is yours. Thank you.
Thank you. Merci, Madame Castel-Renard. So my name is Lou Janssen-Dangsalan, and I'm a practicing immigration lawyer out of Toronto. And I'm sharing my entire basically web browser right now because I'll be flipping through between. But as you can see, I have a slide deck here prepared, and I just want to kind of like preface this entire presentation by saying that this is really 2-3 steps back from what we just heard from Danielle in her wonderful presentation and amuse-bouche for the automation of immigration processes. So I want to take several steps back, essentially looking at artificial intelligence, the rule of law, and democracy, and prefacing this by saying that this is essentially one of the first steps I'm taking for a future research project that I'll probably be undertaking in the next 2 to 5 years as we go on. I want to navigate the future of immigration in Canada by contextualizing it in governance, essentially responsible government. So hint, hint, those of us in the legal field, this is a very important buzzword. And also with the issues fundamental to a lot of us living in today's society of transformation through technology, because we know that a lot of us are essentially put in a place where we're questioning the values of democracy itself. We're questioning the ability to actually do free speech with essentially technology being an omnipresence in our day-to-day lives. So without further ado, I want to basically give you an overview of this presentation. I'll say that there are 3 parts to this. The first part will be presumptions on democracy. The second part would look into and very briefly go into where the literature stands. And finally, the third part is where are we? And are we at the precipice of something big? So for the first part, I want to start with certain presumptions. There is a fundamental presumption that we are in Canada and that it is a democratic state. It is founded on the principles of responsible government and good government at that, and that we believe in the concepts of accountability and transparency. I want to kind of like, provide the perspective of a legal practitioner, a lawyer, that is, from the jurist's perspective. It's that there is a fundamental question of who is government. And I want to put our attention to one case law that comes from Will's hometown, home turf, British Columbia. And this is the Greater Vancouver Transportation Authority and Canadian Federation of Students, British Columbia component. This is a decision from 2009 from the Supreme Court of Canada, where Madame Justice Deschamps basically confirmed that government cannot hide from the charter, from the scrutiny of the charter, by creating organizations separate from government and then delegating government functions to those organizations, that they should not escape charter scrutiny. To essentially put context to this, what we're talking about is that governmentality or the ability to actually govern, a governmental action cannot be hidden into essentially subsumed and delegated into private organizations insofar as it escapes charter scrutiny. So there are a couple of concepts there, and I would like to unpack it essentially for those in the legal profession and for those who are actually immersed in the literature in the academic world as well. There is the horizontality of the applicability of certain charters of rights or bills of rights across Canada, but there's also the vertical application. So what do I mean by this? Vertical would basically deal with, say, for example, the Canadian Charter of Rights and Freedoms, wherein governmental action is governed from essentially like it has to be framed and you're protected as an individual from government action and you're guaranteed by the charter, except for the moments where there's the invocation of the notwithstanding clause, of course. But then you have the horizontal aspect to this as well. So for the province of Ontario, you have the Human Rights Code, and each province would have it, including the province of Quebec, where you have the Charte des droits et libertés de la personne. So everyone in the legal profession knows how to basically make that distinction that if it's a private matter, if it's a private organization, for example, that may be infringing on your rights from against discrimination, this would be the charter or the Bill of Rights that would apply. Whereas if it's governmental action, you have recourses through the Canadian Charter of Rights. So why is this all relevant? Because what we're seeing is basically a blurring of the line between the public and the private when we're talking about the rollout of AI technology. And this is quite fundamental because we are at a societal, and I would say as a global societal juncture. It's very historic in a sense that our framing and fundamental questions of what is governmental action and what is democracy and what is the principle of transparency and accountability, they're put into question. And what the literature says, and we're now in part two, what the literature says is that there is an accountability gap. And what the literature also shows us is that there is a struggle because the fundamental distinction between private and public have always been a useful heuristic in terms of understanding governmental action versus non-governmental action. Again, the vertical and the horizontal applicability of our protections. There's also a privatization of governance. That blurring of the lines is very important. And as we can see from that earlier decision that I just cited, this was an attempt to essentially shield governmental action from charter scrutiny by claiming that it's a private organization. It demonstrates that currently the state of Canadian law actually allows for a certain malleability and a certain interpretive creativity. I suppose like my fellow lawyers would love it when I say the living tree doctrine that allows us to essentially adapt our charter to the current realities of society. And that's very important for the survivability of our laws. The principle of the rule of law needs to survive changes in society. And there's also the theme of deepening asymmetries. And this is very much shown in the literature, such as those written by our friend Petra Molnar, those who talk about artificial intelligence, bots at the gates, where we see the governmentality essentially permeating through technology enabled by third parties. And that's very important. Again, that goes back to the blurring of the lines between the public and the private. And it's a common theme that we find in the literature. And what we see as a kind of like as a prescriptive point that a lot of the authors provide is that there needs to be a strong framework to address the challenges brought about by technological change. But you'll see in the further slides here that, interestingly, that may not necessarily be the panacea, the silver bullet that we're looking for. Again, like, as I mentioned, this is kind of like an overview, my first step for a bigger research project. And I've identified a bunch of literature that I've been like looking at. And one thing that I'm going to do is I'm going to put our friend Will Tao in the spotlight here by saying that he was part of a study from 2020 with Lisa Ruth Brunner. It's titled The Artificial Intelligence and Automation in Migration Governance and International Students, an Accidental Ethnography. And what's interesting about this particular piece is that Will has been steeped in the practice of law, immigration law specifically, and in his experience, he was able to document essentially the rollout of technologies and tools, as it starts from GCMS. Danielle gave us a very powerful overview earlier. And to the time when Chinook was revealed in 2001 through our friends at the bar, especially through Zainab, who suddenly sent a message to Will, and Will alerted me as well at this time. And to give you context, as a practitioner at the time, I had this terrible feeling of being gaslighted all the time when decisions would come from IRCC telling us that our application, for example, lacked logical coherence. And Will knows, he's practiced so long in the field of international students and immigration, that we put our heart and soul in these applications. We put our best efforts and our best foot forward when submitting an application for study permits to visa offices, only to be sent a refusal that says that basically Will's submission is illogical, or doesn't make logical progression sense. So it's in a sense very gaslighty. And when that decision, or when Chinook was when it came to light that they were using this type of technology to triage at the very least and facilitate automated decision making. Of course, they will deny this, as they have denied it on their website, as Professor Bélanger mentioned earlier. It kind of like was a moment of affirmation that, hey, actually, it's not us, it's them. So it's not you, it's not me, it's actually you, to kind of like paraphrase that classic love line. But all that to say is that there were common themes in the literature that I've just identified. And to go to the third part, as I mentioned, some of the questions fundamentally, that strike me are, what are our core values? Why are they important? Is it all pessimistic, what's happening with the rollout of the technology in the age of artificial intelligence, automation, and immigration, and the administration of such system? So the purpose of this overview is really to help me frame a project, as I mentioned earlier, that I will be embarking on in the next 2 to 5 years. And some of my initial conjectures from this is that the literature more or less provides solutions through frameworks of governance at the macro level. So that's really interesting. And that's kind of like, emblematic of the works of Paul Nimitz, for example, who says that, yeah, there's got to be like this large framework that governs all of this. Except the problem is power and information in the age of AI and automation is kind of diffused because of the blurring of the lines between the public and the private. We need to be nimble as well as scholars and as academics. And forgive me for citing one of the oversighted grad student philosophers, our French philosopher Michel Foucault, who basically talks about power as a web, that there are points in that web that we essentially see as a form of concentration of power. And there's also the notion of surveillance. And that, my friends, is actually very emblematic of what's happening today, where information or data, big data, is actually at the hands of private entities. So these entities take on a quasi-governmental function, in a sense of being able to triage data, to understand society at a fundamental level that no one ever has, not even governments have to this age. So what's interesting about that is that to approach it from a classical perspective of a distinction of private and public is problematic, I would argue. Rather, we need an adaptable and nimble and malleable framework for approaching AI and automated decision-making and governance. And for fellow practitioners, this involves having a sociological imagination, the framework to advocate and hammer case law. The advocate incorporates the arguments for responsible government. And that really kind of like allows me to go back to that first case that we cited, the Greater Vancouver Transportation Authority, that case, that actually it goes back to case law for me, that there is actually room in the Canadian legal framework that allows us to adapt to the changing nature of technology that fundamentally alters the way we govern society and vice versa. So thank you so much for your time, and I will pass it back to you, Danielle. Merci.
Thank you, Lou, for this very inspiring vision of your thought and about the link between academic and practitioner approach. I really appreciate it. The next guest and the next panelist is Zinab Ziaye Moayed. I'm sorry, maybe you can tell it yourself. And this is a great pleasure to welcome you as well. And I give you the floor. Thank you, Zinab.
Thank you very much. And thank you for inviting me to be a part of this panel. I hope you can all see my shared screen. You can? Okay, perfect.
Excuse me, I forgot to introduce you properly. I'm sorry. I just want to precise that you are a partner at My Visa Law Group and a founding member of ANIC with Lou and Will, and a member at the Federal Court's AI Working Group and reviewing thousands of visa refusal. And you led. You have been led to key insights on the Chinook tool, and I'm sure you will have the opportunity to talk about this in more detail. Sorry, Zinab, you have the floor. Thank you.
Thank you. I appreciate that. So yes, my presentation today is probably a little bit less academic and much more focused on the lived experience of the applicants I deal with on a daily basis that are interacting with this system. And it does come from that experience of working for the past, particularly 4 years, reviewing thousands of applications, whether visitors, study permits, and work permits that have been refused, and seeing the impact that the adoption of a lot of these tools have. First of all, it's extremely difficult to do a presentation in 10 minutes, so I am thrilled by what Danielle and Lou have done. I'm just going to try and keep my remarks as short as possible. So the world in which applicants are living in is one where these ADMs are able to operate because we have increasing online-only or digital-only interactions with the Immigration Department. So IRCC is Immigration, Refugee, Citizenship Canada. And for the most part, over the last decade, and particularly since the beginning of the pandemic, there's been a great push to make all applications online. And while there are benefits to this kind of streamlining, as with other, adoption of technology, there are serious challenges that applicants are now facing as a result of that. And what I'm going to be speaking about is what some of those challenges are when we've removed essentially the ability to have human interaction, particularly in complex processes such as visa decisions and visa applications, but also when things go wrong, the lack of ability to reach a human decision maker and somebody who can actually look at the whole application besides just a couple of data points. So what we're seeing right now is, sorry, I'm just gonna surround a little bit. We have a shift to the use of automation. Danielle spoke about this, and there is more and more information now that we have in terms of what some of the tools are. But what is essentially happening is that almost all communication channels with IRCC are now primarily digital interfaces. So we submit applications through portals. We receive any communications either through portals, perhaps through an email interaction. And if we want to communicate with IRCC, we used to be able to send packages back in the day, but we used to also be able to send emails specifically to a particular visa office. This goes back to the idea of space that Danielle spoke about, but now we can't do that. It's almost exclusively through a centralized web form system. And we know, on the other hand, that various types of technological tools and ADMs have been adopted, from the triaging of applications to AI-based risk analysis, and of course, Chinook-assisted decision-making. So these are the things that are impacting almost every visa application that goes into the system before it even makes it in front of a human decision-maker. If it makes it in front of a human decision maker, it will have undergone some levels of automation. It will have maybe had summaries, would have been triaged. It will have passed through these automated processes to even get before a human decision maker. Okay, so what are the negative impacts that we're seeing? The biggest challenge that we've really seen over the past 4 or 5 years where these technologies have been adopted without testing is the accuracy of these tools, and the output is a lot of complete applications are being incorrectly refused. So applicants are facing negative decisions, and I really like the term that Lou used. For a long time, we felt there was a lot of gaslighting because the applications are complete, the decisions appear to have, reviewed the application, but they actually hadn't. And the patterns we were able to see over dozens and then hundreds of internal GCMS notes revealed that there was striking resemblance, if not extremely verbatim reasons from application to application. And once we learned about the use of Chinook, we realized that it wasn't just a copy and paste sort of situation, that it was being generated by the Chinook system. And what ends up happening to applicants is that if they've submitted a very complete application and they're receiving a negative determination, so within, let's say, the study permit context, there is not a lot that they can do. And just before I get into what options they have, I also just want to touch upon the technology. I think a lot of the mistakes, the incorrect decisions we're seeing is because the technology is really not there. I think as with a lot of other AI technology that's being rolled out in other areas, whether it's in decision-making or basically in other parts of society, we tend to think that it has a much better efficacy rate, but it doesn't. And we don't have, as private practitioners, even though we've done a lot of access to information requests and so on, but we don't really have a systematic study on what the error rates are on these decisions that are being made by IRCC. We do have some indicators, I would say, that sort of point in the direction of that there is significant challenges with the use of these technologies and the error they have. One is the high percentage of judicial review applications that are in fact successful. So when we do a judicial review application, we're saying that the decision is unreasonable in light of the evidence that was presented. And if we're getting the government coming back and settling a lot of those, I think is an indication that they accept the decisions were not rendered correctly. And then the other more recent sort of data point is, there was a Globe and Mail article about this maybe like 2-3 weeks ago. CBSA is increasingly turning away applicants who were approved for visa. And they arrive in Canada, but they're actually being determined to not be eligible. And this probably goes back to that triaging tool. Remember, Danielle spoke about this. If your triage is low risk, you're almost certain to be able to receive the visa. You're going to have automated approval, versus if your triage is high risk and it's going to go through an officer. I think that the recognition that potentially some of those approvals by the system as low risk are actually incorrect, and therefore CBSA is sort of stepping in to make sure that anyone who's coming in is going through that process. So keeping it very brief, the challenges that applicants have when they have a refusal, they can try to reapply, but the algorithms on, whether it's in Chinook or within the triaging and so on, if you've had a refusal, you're going to get caught in a negative loop. That's going to be a factor that's considered within the algorithm, and you're much more likely to face a second, third, and subsequent refusal. Again, there's minimum or really no human interaction and involvement in rectifying these errors, and therefore, one of the only options that remains is for applicants to be able to seek judicial review in federal court. This is very problematic. IRCC's refusal letters do not actually outline that applicants can have the option to seek judicial review. There's a standard form letter. It has changed a little over the years, but it does say you can reapply, but it does not speak to the right for applicants to seek judicial review. And so I think that the limiting factors on applicants being able to even access this remedy is limited knowledge. If you've applied yourself, you don't have a particular legal background, and you're not in a community that maybe knows about this option, you don't even have the knowledge to be able to pursue judicial review. And even if you did, there are costs associated with the judicial review application, even at the lowest sort of potential fees that there are available for doing this kind of work. It's still a potential consideration in terms of access to justice. So I'm mindful of my time. Just really briefly going over the limitations of what judicial review can actually do. Judicial review and the ways in which we can understand what the refusals are. Judicial review is limited for us to be able to get to the root of what's happening. Some of the big questions that Lou was just speaking to in terms of how we want decisions to be made, what are fair decisions and things like that. There isn't a scope within an individual judicial review application for us to really go into those fundamental questions about procedural fairness and how we want AI assisted or AI decisions to be reviewed within an administrative law context. So the legal tool we have is limited. And many times applicants feel that, even if they get resolution on judicial review, the real concerns that they have are not addressed, that their applications were not really reviewed. And that goes back to that idea of gaslighting. We're being left with a really bad experience of knowing that even if I submit a very complete application and I follow the requirements, there's nothing on the other side of this bargain that there's actually going to be an officer that's going to review my application, exercise discretion, and make a determination. I already discussed the access to justice issues, and because we, individually are looking at these, the negative consequences and the system remains in place, even if we're able to reverse individual decisions here, there, and so on. The system continues to operate. And at some point, the immigration authorities have done the calculus and believe that, they're able to get through literally millions of applications using these tools instead of revising them and putting a focus on the experience of applicants. And just to sort of wrap this up, the negative consequences that applicants are feeling, the emotional toll, they're losing time, and there is a financial burden that's being put on them. Through a lot of the social media work that myself and Will and Lou have been doing and others, there is increased awareness around these issues. So I think that's helpful. And at the end of the day, I want to sort of leave us with this, which is, unfortunately, as a result of this, there is an increasingly negative perception towards the way Canada's immigration system is viewed. It's viewed more as unreliable, unpredictable, and unfair, which is not the kind of reputation one have. And I think that's a shame. And these tools are going to continue to be used. So we need to come back and keep advocating for the immigration authorities and the government to take this issue much more seriously.
Thank you, Zinab. I'm the timekeeper, and I just realized that we're running late. So I'm going to ask to the next panelists to keep their intervention in 10 minutes, please. Will Tao will be the next one, the next panelist. We are very glad to welcome you, Will. Will Tao is the founder of Huron Law Offices and the author of the Vancouver Immigration Blog. He's completing an LLM at LRUBC exploring the foundations of the automated administrative state in Canada through the lens of Canadian immigration law and the federal courts. The floor is yours, Will, and thank you.
Thank you so much, Chair, and thank you to all my co-panelists. It's such a pleasure to be speaking alongside folks that we've been doing a lot of thinking with over the years. I want to begin with a territorial affirmation. I am speaking today from the stolen, unceded traditional territories of the Coast Salish peoples, the Squamish, the Tsleil-Waututh, and Musqueam nations. And as we head into TRC Day, my firm offers a pro bono project to help Indigenous folks reclaim their traditional ancestral names, and I just want to draw resource attention to that. I'm going to skip again for purposes of time. I want to get to the heart of my presentation. We did talk about this. Thank you, Chair, for discussing a bit about the definitions of what an automated decision-making system are. I won't go over that again, but it's important also to break down that there are the use of advanced analytics. This is sort of IRCC's main tool to predict and prescribe, and this involves their risk triaging and automation approvals. And the end goal, as we discussed, is productivity and reducing processing times, which is a common theme among immigration's sale and of why they're using these tools. You know, the quicker we process the easy cases and automate the approvals, the more time humans have to decide the more difficult ones. And with these sort of caps that we're seeing, we're actually seeing a very different reality play out. And this is related to the tool of fettering discretion. This is obviously a very complex legal term, and I don't want to purport to try and explain it in 2 minutes. But the idea is that the officer, and this goes to, again, Danielle's presentation on discretion, they have to, they can't bind themselves to a fixed rule of policy. They have to, or the outputs of a decision support system, they need to put their mind to the circumstances of the case. And if you think about the conversation we've had about Chinook already and how it forces officers to make decisions quickly and not view a large portion of the application, obviously the fettering of discretion becomes one of the major flaws, possible flaws of these systems. Another one is the term black box, right? And this has come up a lot in popular literature. And what it means is these systems that are working outside of meaningful scrutiny and accountability. Yes, they could be also deep learning systems, but increasingly also these are the systems that are in the hands of third parties. So for example, facial recognition technology. One of the challenges we have now are that there's proprietary software that makes all the decisions, and IRCC and their staff are only sharing so much about how it works. So in terms of the existing framework of administrative law as it pertains to automated decision-making systems, the focus so far, at least in the administrative context, is on this ex post adjudication framework, essentially judicial review. And one of the challenges of such a framework is, first of all, it's the language kind of is stuck in individuals trying to challenge these systems using court processes that are very difficult to challenge these decisions with. But it stays within the context and the sort of safety of these terms of reasonableness, notice and participation, bias, discretion, things that we've discussed so far. It is a limiting framework. Increasingly, there's also this call for accountability. And I know a lot of us have this word in our presentations. We need the government to be more accountable. IRCC should be more accountable. But this is also a term that I would posit that Canadian administrative law hasn't really flushed out. And you'll see this actually with a lot of terms. You know, we were like, yes, accountability, yes, transparency. But what do those terms actually mean? And to whom? Which is an underlying question that I'm asking throughout this presentation. I do note, however, that an increasing amount of scholarship is also moving to ex ante frameworks. And this is before systems are built, before decisions are made, as they put together these systems. However, there are a number of challenges. Number one, a regulatory lacuna. There is this broad mandate in the Immigration and Refugee Protection Act allowing for the use of these ADM systems, but there are no regulations on how to implement them. So when this act was passed, they didn't even contemplate the use of automated decision-making systems in using AI. It was very much just, you know, here are new online application tools that'll make things easier. Now the goalposts have shifted, but there have been no regulations to regulate the rules of how the game is played. There's also lack of independent oversight and a watchdog, and Paul Daly writes about this in his work. But you know, who's also the referee in this proverbial match that we're having? And then the role of notice and comment. So as public stakeholders, how are we able to engage in this conversation, be part of the process? Right now, we have this directive on automated decision-making, as Chair Celine has talked about, soft law, very informal, very internal, but they're contrary to best practices. We're not able as stakeholders to even comment and provide our feedback unless specifically invited, which actually recently, just past week, Gabrielle, Lou, myself were part of a submission to the Treasury Board Secretariat where we actually gave feedback on their AIA guide. But often in our feedback, we say, why us? Why not more people? You know, are we really getting to the heart of all the individuals who are impacted, especially the users on the front lines. So this is sort of the heart of my presentation, and I'll try and summarize it in the 4 minutes I have remaining. These are thoughts I'm grappling with. So similar to Lou's presentation, I'm presenting actually not on stuff that I've spent, years studying. You can read some of my writing on that on my website and other things I've published. I have a new idea, a concept, and I want to share it, and I want to see everyone's, how can we move this conversation forward? The idea is these foundational cases in Canadian administrative law that are in immigration, your Baker, your Kanthasamy, your Vavilov. How would those decisions look different if ADM was present in them? Or how would they be redecided if now government had the tools of ADM? How do we deal with bias in the context of this? And do we need to rethink bias and dig deeper? What happens about discretion? And I know Danielle's wonderful presentation on discretion in a sociological context, but in law, there's a lot of problems with this use of bias and this definition of bias. And same with the transparency as a sort of concluding thought. So I just really want to summarize questions, and hopefully I'll share the slides with everyone afterwards so you'll be able to look at this in more detail. But imagine Baker, where there was a triage already to high-risk countries, right? If Jamaica was on a high-risk triage list, country of citizenship. The junior officer's notes that, this case is all about this officer who was blatantly racist and wrote a bunch of, said the quiet part out loud. What if those notes were off the record completely, deleted, not available? What if the wording was generated by a large language model that used the proxies for race and cited data instead of subjective feelings, right? And an officer could still render the same decision, but it wouldn't be coded in that language. And Kanthasamy, right? I'm not going to go as much into detail about this case, but this is our H&C benchmark most important decision. It was because they used the wrong wording of unusual and undeserved, and they were dismissive of a psychologist's report. But what if they could, use new systems or reasons generators to void those words that are problematic? What if IRCC had the predictive ability to decide which cases would succeed and would not succeed, and use that data to drive the decisions? And same with Vavilov, right? This is the foundational case in Canadian administrative law. Another junior officer involved who made an analysis. Unfortunately, that was shown, and then the final officer made a decision with no reasons. But you can think of, with the use of ADM tools, how the paper trail or the audit trail, or even who made the decision at various points, could be swept off the record in a way that no one would know, and it could be assumed that that junior officer was actually the senior officer who had rendered the decision, and their reasoning would stand in for the final decision. And we're seeing that, of course, in the temporary resident testing grounds that Zeynep has discussed in her presentation. So again, to keep within 10 minutes, we talked about automation bias already. Previous presenters, I put a definition up on that. There's also complacency, right? Relying on automated decision-making systems instead of an officer's own instincts. But I would also challenge that bias needs to be considered also in the tech perspective, right? Because now you have technologists developing these systems who have very different views of bias. They look at bias as errors, as equality rather than equity. There's a difference between societal bias and technological bias. There are different types of biases, as I've outlined in this slide. So when it comes to discretion, one of my core arguments on discretion is that right now we've seen the loss of discretion as a main argument. This idea that once we use these ADM tools, discretion will be lost. There'll be no more empathy in decisions. Humans are gonna turn into bots. But I also do want to highlight the work of Jennifer Raso, who looked at it in the Ontario public works sector and saw actually humans navigating the systems, almost manipulating them to achieve results that they want to see. So, you can think about it in a positive way if someone wants to help someone, but you can also think about it in the context of that Baker officer. I really don't want people from certain countries in my country. Let me just manipulate it so that none of my reasons show up, but I can get the end result of this person being denied into Canada. So one of my points is the problem is not necessarily that human discretion was not present in any of these cases. It was that it was unreasonably applied, but we could see how that was applied in a clear way. So this is where I have concerns about ADM trying to avoid another Baker by hiding how that works. And I'm going to conclude in just I know I'm a minute over, so I'll just conclude in about 30 seconds here. I don't see transparency as a long-standing solution to this. And for many reasons, even though transparency is a foundational concept in Canadian immigration law, the feasibility and desirability, especially as national security systems become the core of what the government seeks to protect, will they be able to reveal the AIAs and the DADMs about these complex systems? Will they be able to talk about how security works in triaging? So we need to get to a system where we adopt and understand the tech perspective of concepts like traceability, of auditability, of end users being able to contest decisions and having mechanisms to contest. So we need to rethink transparency, discretion in the context of how these ADM systems are moving forward and impacting the users at the core and who are being negatively impacted, as Zainab's presentation so eloquently put it. So sorry, this is probably a 30-minute presentation. I try to cram it to 10. It happens all the time, but hopefully in the comments we'll have a bit more discussion on some of these in a bit more detail. Thank you.
Thank you, Will. It was really inspiring as well. And the last panelist today is Gabriel. Gabriel Bergevin-Estable is an master candidate in geography at University Laval, studying the effects of AI and automation on migration. He's also a regulated Canadian immigration consultant and works as an immigrant caseworker in the constituency office of Quebec City. Thank you. Gabriel, the floor is yours.
Thank you, Professor Castelrenard. This talk is titled Grandma is Not Coming. It's a reflection on rights at the intersection of AI, disability, school exclusion, and migration. The image you see is a Korean grandmother and baby by photographer DOK1 and his license Creative Commons 2.0. I'm a candidate for MSc Geography, as you said. I'm also a member of a local right to schooling committee at the Ligue des droits et libertés, section de Québec. And this presentation is really the result of an intersection of interests and research areas. So the idea for this presentation came from concrete problems faced by constituents throughout my caseload at MP Joel Lightbound's office, and discussion with a social worker, Rose Corriveau, who could not present with us today, and the many collaborators of the MAIA projects, many of whom are here. So I want to share merits of some of the key ideas, but I am solely responsible for any mistakes in the presentation. So as you heard, IRCC has implemented AI solutions that triage applications for automated eligibility approvals on visa applications. What I'm discussing today relates to the two advanced analytics solutions applied to temporary resident visas, and they fast-track processing for cases with high and provide high approval rates for ideal low-risk candidates. This AI triaging replaces manual triage methods. Contrary to older triage methods, it does not take into account factors such as time sensitivity, humanitarian urgency, or questions of human rights. The triage method is not based on the needs of the applicant, but on the likelihood of application approval. If a less than ideal applicant has an urgent need to come to Canada, few visa offices have urgent application flagging procedures to compensate for this oversight. And those that do seem to not have updated those procedures, which were designed for paper applications, for today's online applications in the digital age. So they've aged out of usefulness. I refer to the Mexico City Visa Office instructions that are still available on the website, but for only for paper applications, which almost no longer exist. Why is the processing time important? Well, if your motive of travel is time sensitive, such as coming to assist a birth of a member of the family, but processing time for typical applications is longer than a pregnancy, there's no possible way for you to apply on time to get the visa on time to assist a birth. You'd have to guess that the person will become pregnant months before they actually become pregnant. So some visitor visas take a long time to obtain, sometimes more than a year. And if it's not triaged on a fast track to approval, the wait times are unrealistic for certain travel objectives. So So in the past, IRCC has recognized in some internal documents that some applications can be simultaneously time-sensitive, complex, and high risk. For instance, medical emergencies or attending funerals, seen in this internal IRCC document. So some of these non-routine travelers will be traveling for reasons that could qualify for humanitarian compassionate considerations in processing and triaging, but they won't be triaged into the fast track by the AI systems. So this shows an initial blind spot on which I want to zoom in a bit more. So IRCC considers that both the processing and the triage by AIs of TRVs, temporary resident visas, raises no important questions of rights. It has stated so in its algorithmic impact assessment for advanced analytics and has presented this position in federal court as well. Federal court judges have often concurred, and those who wish to see examples may read two recent cases I cite at the bottom, Tayabi, 2023, and Carr, 2024. So can that be the case that some of these applications, don't raise questions of human rights, but at the same time, they raise humanitarian compassionate considerations? There seems to be some sort of contradiction. IRCC says they don't raise questions of rights, but that's categorical thinking. A single counterexample invalidates the blanket statement. So I want to talk about school exclusion now. Quebec schools are excluding more and more children because they're considered a burden on limited resources. This must not be confused with voluntary deschooling or homeschooling, which is a preference for some families. School exclusion is against the parents' wishes and is why we created the Right to Schooling Committee. It disproportionately affects children with autism, other conditions, and handicaps, usually referred to as special needs children. There are thousands of children affected each year by conservative estimates provided by the government of Quebec. So sending the kids home instead of school can affect their development, and most of those affected are handicapped or otherwise vulnerable. It also has significant impact on families. Parents must spend more time and expenses awarded to care work, while their time for work and the family income tends to go down. And these consequences impact women and mothers disproportionately. They want help at home, and usually they want that help from their own family members, which is understandable. Sorry. So back to our immigration questions. So some of these families affected are migrant families whose extended family currently live outside of Canada. Migrant families in Canada call on family members as caregivers slightly more than other families based on government studies, but the caregivers selected tend to share the same profile. As for other Canadians, the ideal caregiver is someone with experience caring for children who is free from most other economic or family obligations, is slightly older, and can intervene in the domestic sphere in a culturally relevant manner. In other words, most families want grandma. Though the selection criteria are the same, for migrant families, grandma may have to apply for a visa before coming. Now, here we can see in red all of the countries of origin whose citizens need to apply for visas before coming to Canada. Not all families require visas, but of the top 5 countries of origin for permanent immigration to Quebec since 2019, only France is visa exempt. Family from Cameroon, Morocco, Algeria, and China will all require TRVs. The processing times we saw earlier were for Cameroon, over 1 year. So on the so also what's important is that visa approval, of course, is not guaranteed. So by far the most commonly cited visa refusal reason is based on Regulation 179B. The officer must be satisfied that the person applying for a TRV will leave Canada by the end of the period authorized for their stay. From January 2018 to March 2020, data obtained from IRCC, 65.8% of refusals reasons cited were based on this regulation. In this recent federal court case, Kashefi, 2024, it shows how IRCC and the courts can see grandparents visiting their grandchildren, how they interpret that as a potential motivation to stay indefinitely in Canada, and exposes them to refusal on this count. So in particular, the officer may wonder if the applicants want to settle in Canada to be closer to their children and grandchildren. So we have a first obstacle here for grandma, is how her intent to stay here will be seen. If we dig deeper in the statistics of refusal reasons, what makes grandma an ideal caregiver, that she's a family member, that she has limited family and economic obligations in her country of origin, that she's willing to drop everything on a dime to come to Canada and help out for an indeterminate period of time for as long as she is needed are some of the very same specific push and pull factors that are most often cited to refused applications based on Regulation 179B. So insufficient financial assets, she doesn't have financial obligations, no job, no business. 16.2% of TRV refused cite this reason. Family links in Canada are stronger than in her own country, 12.1 cite this reason, and so on. So the best profile for a caregiver may be the worst profile for a TRV. So how can they argue their case? How can they bring their case forward? And Canada is a party to several human rights treaties. I'll note the Convention on the Rights of the Child and on the Rights of Persons with Disabilities for this case. These treaties entail a variety of substantive rights with obligations on the part of the state. They're supposed to guide how IRCC applies and interprets administrative law. In Canadian immigration case law, the role and importance of international human rights, including the best interests of the child, have been recognized at Supreme Court level, notably in the Baker and Vavilov cases. So in principle, the way IRCC manages these TRV applications by grandmothers should consider the best interests of the handicapped grandchildren who have been suddenly excluded from school and need significantly more care work than before. I filed 3 access to information requests to try to understand how IRCC is managing this issue. The first 2 for instructions provided to visa officers on processing TRV applications for this kind of case. And the third for a similar request on another topic where constituency offices are often solicited. The TRV for a family member coming to care for a woman experiencing a difficult or at-risk pregnancy, a first pregnancy, or to care for young children around the time of childbirth. The first 2 requests came back negative, but on the second request, IRCC clarified that the responsible program area has advised that there is no specific guidance on this. So officers are left to their own devices, whether they are aware or not of international rights obligations or of the particular needs of handicapped or autistic children. The third result showed us some interesting disclosures relative to measures during the inbound air travel ban from 2020 to 2022 because of COVID-19. So during this time period, IRCC had lifted travel restrictions for immediate family members coming to Canada if they had certain mandatory, non-discretionary, non-optional reasons for travel. So this did include a foreign national coming to Canada to support family around the time of the birth of a child, but they also included those coming to Canada to act as caregivers for immediate family members, for childcare, pregnancy, disabilities, or the elderly. So IRCC has recognized during the COVID pandemic in certain measures that these are important non-discretionary travel reasons, caregiving for children and the disabled family members of the foreign national, and that these people should be let in. Though it was limited to immediate family members, it was certainly responsive to this kind of need and situation. Sadly, these measures and special instructions disappeared as soon as regular air travel was restored in October 2022. So as for many other topics related to disability, special measures applied during COVID were very relevant, but disappeared as soon as the crisis was perceived as ended. So in conclusion, IRCC's advanced analytics triage measures, they grant priority processing to low risk, low complexity cases without regard to humanitarian considerations or international human rights, yet complex, high risk, time sensitive cases exist. Family caregivers coming to help handicapped children, victims of school exclusion fit the bill, and also raise questions of international human rights, including substantive rights like the best interests of the child. The probable profile of ideal family caregivers like grandmas and aunties does not correspond to the profile of ideal travelers and corresponds to often used refusal reasons. So they will be disadvantaged in a standardized uniform process, such as those that are being pushed by automation. And during COVID-19, IRCC was able to recognize these are mandatory, non-discretionary, non-optional travel purposes that should be allowed despite extreme travel restrictions at the time. However, IRCC failed to generalize such learnings and to generate instructions or guidance for officers as to how to handle these cases post-COVID, and none of these concerns are taken into account when IRCC is considering the risks for the AI triage of temporary resident visas. So until something changes for many families, grandma is not coming. Thank you.
Thank you, Gabriel. And I'm sure we will have many questions after your presentation, and we already have a lot. And so I go directly through them. First of all, I would like to ask to Zinab. Two questions are specifically addressed to Zinab, and I propose to aggregate several questions at the same time. The two first questions are for Zinab, and the third one is for everybody, and maybe Daniel. The first question, what kinds of visa applications get refused the most through this automated decision-making, students, super visa, etc., in your experience? And do we know if IRCC are aware of these issues? And for Zinab and everybody, and probably Daniel, what is in place in Chinook as decision indicators?
Okay. So with regards to, can you guys hear me?
Yes.
Okay, perfect. Going back to the efficiency sort of goals that IRCC has, Chinook has been used predominantly and extensively in some of the big volume application types. So we're talking about visitor visas and study permits in terms of volume, and that's where it's had the most impact. Super visas fall under visitor visas, so those are also impacted. Technology and other tools are seeping into other types of applications. We're seeing them in, H&C applications. We're certainly seeing them in some work permit applications, but the big categories would be study permits and visitor visas. And I think the other question was, is IRCC aware of these concerns? I believe they are, because if nothing else, we have been sort of shouting it from the rooftops. They have been part of our the Canadian Bar Association panels over the last couple of years where we have voiced these. We know that they follow us on social media and they sort of, are aware. And we have been quite vocal and tried to, bring our perspective in terms of the perspective of clients and what these issues are. So I'm sure that they are aware. They have different instructions and priorities, but they're certainly aware.
Thank you. And Daniel?
I want to say that this is not the question for us, because what we're interested is how Chinook is inserted in a huge infrastructure. So we cannot just take it separately and say because it doesn't make decisions per se, it's okay. It doesn't, for us, it's not how it works, right? For instance, medical inadmissibility is determined by RCC medical officers in the London office. Security-related stuff is greatly determined by partners, such as CBSA or CSIS. Criminal background checks are automated thanks to biometrics data, information sharing with the Migration 5, and all these different other agencies use their own tools, right? And this information is fed into the system. So we have to look at it much more broadly. And then what we wish to point out is in this system, files are necessarily pre-processed based on similarities, past decisions that feed the algorithms, and rather than being analyzed individually, as Zinab pointed out. And that's really the point. So I think we have to ask the question differently.
And maybe Will or Gabriel or Lou would like to answer the question of what is in place in Chinook as decision indicators.
I can give it maybe a first stab, decision indicators. So I guess there may be an issue as well with the framing of the question, but Chinook itself has a module where risk indicators are provided to the processing officers. And one of the issues we have when challenging these decisions is these risk indicators are often omitted from the applicant's own knowledge. And even IRCC is a little bit gray on whether the officers who process it see it or only a risk assessment officer who's working behind the scenes is actually looking at it. But we've come up and found numerous decisions where these risk indicators appeared on files, but the files were actually refused for different reasons. So there would be concern with the consultant or finances, but they would be refused on purpose of visit. So one of our big concerns in this space, especially with tech just generally, is this two-tier decision-making where what the public sees and what individuals get is one description, but the real reasons for why folks are refused are these opaque algorithmic-based systems that are operating behind the scenes, and not to the knowledge of those who are impacted. So that'll be my kind of summary of that question.
Mm-hmm.
I'll take a second stab on this just to add on Will's point about the use of risk flag indicators. And that sort of really highlights the fact that officers, if they even manage to get there and allocate enough time to this, because we know that they're doing this in 6 minutes for each decision, is that they are considering extrinsic evidence technically from a procedural fairness perspective, just looking at it from a legal perspective. But as Will clearly put it, basically, it is something that is not written into the reasons. You have to glean into it, and you have to basically be able to interrogate and examine the officer who rendered the decision. A luxury that doesn't really happen often, very rarely. I've seen Zainab do this in action. It was terrific. But at this, at the end of the day, like if you're looking for those flags, unfortunately, they won't really be indicated.
Mm-hmm.
Just a final pass on this.
Yeah.
There's a certain amount of information that's in front of the officer at the time that they make the decision on the application that was not included in the application. And any local word flags or risk indicators might affect both the process of processing the application, such as digging deeper in certain background verifications, or handing it off to another team to look at it. But it can also affect the outcome, of course, depending on what results from those procedures. But also pre-assessment notes, usually made by locally engaged staff, will summarize the content of the application for the officer. And so the officer, we understand, most likely is actually looking at this summary rather than the full contents of the application. And the way that summary is made, of course, could affect the final application, but once the decision is made, it's deleted. The same is true also of the officer's own working notes. And if the officer made a group decision, so if they selected 20 or 30 applications or more based on common criteria to issue them identical refusal letter because they were being refused on the same grounds, we don't know to which group a file was assigned before it was refused. So there's lots of information that's in front of the officer at the time of making the decision that's not a part of the candidate's application, that will also not exist in the court records that are the records that are given to federal court, or disclosures when you file an ATIP request for a copy of your case notes.
Mm-hmm. Thank you. I'm going to ask 2 questions for everybody. Are there any systems other than Chinook used by other countries that can be better protect clients' rights? In your opinion, how can we promote a judicious use of AI systems that respect human rights and privacy without creating problems for both policymakers and migrants? Go ahead, Lou.
That's a really good one. It's essentially the question that I asked in my presentation and in my review. I'm trying to look for themes and essentially ways to do this. As I mentioned earlier, there were 2 perspectives that were apparent in the literature as it stands. The macro view, where we need to go on a full all-of-government approach to essentially regulate artificial intelligence. One approach that is essentially live being rolled out is the European Union's essentially efforts to regulate and legislate and govern the use of artificial intelligence in all aspects of life. But then there's also the question of the privatization of governance through the accumulation of data, and data is power. It's the new oil, and it essentially lubricates society and allows us to function. So it's a question of essentially, how do we strategically engage the holders of power in today's age, where power is actually no longer exclusively the locus of governments across the world, but also by big tech, for example? It's the same problem that folks who are advocating for the regulation of social media, for example, face at the moment. The likes of Nobel Peace Prize, Maria Ressa, for example, has been advocating that there needs to be an international framework that governs social media rules, networks rather, and companies are essentially the power brokers here. In effect, if we're looking at artificial intelligence, which I think is an earlier stage than in the governance of social media, we're facing the same problem of the diffusion of power networks. That we may not necessarily we cannot just approach this from a governmental approach. I'm sorry to the European Union. I think they're making a fantastic efforts to this, but I think we need to be a bit more creative because this is a novel problem in society at an historical juncture. I don't have specific recommendations, but some things that I do have in mind are essentially the continued evolution of stakeholder engagement when it comes to the rollout of the technology. The question of the lack of transparency, that transparency gap keeps coming up. Certainly that's a point and angle of attack that we should be thinking of at all times.
Mm-hmm. Thank you, Lou. Someone else? No? Okay. For Gabriel, how to reconcile the human rights of migrants with the national security of the host state in these digital world tools, even if you don't talk about security in your presentation?
It's a really good question, and security questions have not been the focus of my research so far. But at the same time, security concerns are an obligation of the state. The government needs to do certain security verifications related to migration and travel authorizations. The way in which it's done, who gets sent to additional verifications. A lot of this is being influenced more and more by these automated systems. So it's really worth investigating. I'd say that one of the issues is that the government tends to shy away from disclosing how it proceeds in security verifications. The fear is that disclosure of the procedure could allow bad actors to understand how to deploy countermeasures to not be controlled by the security verification procedures. So that's the argument that's often put forth. So it's the issue is when there are humanitarian considerations, human rights cases. If a person is coming to Canada for a medical procedure, but at the same time they're facing security checks that are delaying the processing of their application. My tendency would be that this is, and the lawyers here will be able to answer that better. My tendency would be that you have to go to the courts to be able to balance those interests. I don't think I can say that there's good administrative procedures to balance those interests and considerations.
Thank you, Gabriel. And I think Will would like to add something. Yeah.
And I maybe just want to curb a bit of the optimism from Gabe on his last comment with the courts. The courts are probably not going to be helpful to us, especially judicial review, probably maybe other types of litigation actions, etc. But with the new foreign interference bill and sort of now international relations information being subject to non-disclosure by the government and the appointment of special advocates to deal with that. I mean, we're heading to a period where applicants may not know very little about why they were refused in the first place. But let me just add maybe quickly a real life example of what's going on within this situation and just maybe draw parallels to historical times. So Chinese applicants were historically refused. There was head tax, hundreds of years ago, but there were also ways to stop spouses, etc., from coming. Now in Canadian immigration, it's security delays because applicants from China with any sort of background in media or STEM or having gone to certain schools or having military or government in their family, they're all being flagged for security delays that are causing their applications to be delayed 2-3 years in a system already where we have caps and limited spots, right, that are filled by the automated approval cases. So in essence, a lot of these security issues are morphing into these long-term delay as punishments that are having impacts almost of being like a discriminatory bar on certain individuals based off future risk profile. And I just want to flag that they're not being refused per se, but they're being delayed to a point where they're going to withdraw or find other options, and the kind of outcome that creates for our system if we start doing that en masse. So just a brief thought on that.
Thank you, Will. I really like this question, but I think we won't have enough time to answer it. But just to keep some thoughts about it, to continue to think about it. What is the role of researchers in making the government of Canada aware of this injustice? And I'm sure Danielle and her team will answer this question in this project. So this is the end of this webinar, and I really would like to thank our panelists, very helpful for this very helpful and engaged conversation. It was really interesting, inspiring, and very rich. I need to add, and I saw the information has been disclosed already in the chat, but I need to add that the webinar will be available online on Ovia's website soon. So thank you all. Thank you, Danielle, Gabrielle, Zinab, Will, and Lou. And thank you, Adele, for the Q&A session. Thank you.